Yesterday, just to recap where we were from yesterday and how we would proceed this morning, is that there was an amendment proffered by Senator Underwood, which is on page 6, which is to increase the number from 20 to 30 feet at the entrance or exit of a public place. And members who spoke on the amendment, we had Senator Blas and Senator Rodriguez, and then at that point that we had recess. So we are still on the amendment. There was a request, I know, by Senator Rodriguez to consider the withdrawal of the amendment, and to date I've not really heard where we're at with that. But since we are on the discussion of the amendment, and since most of our members are here, then you will have an opportunity to speak on the amendment before the vote is called, or if not, if there is that agreement. And then we go back to the others who have signed up on the main motion to speak, and there are members who are on the list to speak on the main motion. So for now, we are on the amendment. So, and the last person was Senator Rodriguez, and if there's anyone, you would like to continue then? Okay, so Senator, yes, because I know we ended with you, and you may continue.
Good morning, Madam Speaker and fellow colleagues. Madam Speaker, just to reiterate what I had stated yesterday, is that I personally support the move to increase the amount of the distance between where we allow smoking outside of a entrance of an establishment. However, I believe that this is a substantial amendment that is being made to this bill, and that it needs to go through a public hearing process to get the stakeholders involved. As I said yesterday, there may be establishments that have made investments in closing outside patios or segregating areas outside of their establishments within the 20 feet guideline as per the existing statute. And so I've asked that it be reconsidered, and that perhaps the amendment be withdrawn. And
No.
Thank you very much, Madam. Really gives the flexibility to the courts to be able to, extend some sort of leniency. I remember trying to think back at when we did this measure that prohibited the smoking of in vehicle when a child is present. We took a look at it and really not wanted it to be a punitive, not wanting it to be punitive, but really kind of, and I think one of our good colleagues here mentioned earlier today, really the awareness of the dangers of smoking, especially with this section, smoking in a vehicle when kids are present, because this is what we're removing here really deals with that section, specifically with that section. And so, I'll listen to the discussions, but I just don't believe that that's something we should remove. But I'll listen and see where this discussion takes us. Thank you.
On the ADA amendment, Tony Ada's amendment, which is to delete again, just to reiterate, lines 7 to 11 on page 8 on the suspension of a fine for a violation. Senator Underwood.
Madam Speaker, I do oppose the amendment because I believe that the spirit behind this section here is to encourage the smoker to engage or to enroll or to stop smoking. And to the extent that their fine would be suspended if they prove to the court that the person has enrolled in a smoking cessation program or its equivalent. Did I say that correct? Cessation? Yes. Then, that serves as an encouragement. It's really already hard enough for smokers to stop smoking, but when they're found to have committed their first offense, maybe this might just be that chance, that opportunity for them to stop smoking. I believe that the spirit behind this section is not to punish the person, but to also encourage them to stop smoking. So that's the basis for my opposition. And the first lines 8 and 9 actually acknowledges good citizenship. If they have not been convicted of a violation of this section in the past, and this is the first time, then we're really saying that if this is your first time and you enroll in this program that will help you stop smoking, then we'll hold back in fining you $100. So I for that reason, I really would hope that this would stay in the bill. Thank you.
You're welcome, Senator. And I have Senator Nicholas and Senator Tom Adda.
Thank you, Madam Speaker. I can see where the retiring speaker is coming from. For me, I actually need to rise in support of the amendment. And the reason is because that subsection C, lines 7 to 11, have to do with subsection B, which is the fine relative to subsection A. And subsection A basically says smoking is prohibited in a motor vehicle if a child who is 17 years of age or younger is present in the vehicle. And so what this amendment will do is it will say there's no first pass. If a child is present and you're smoking in the vehicle, you will be assessed that $100 fine immediately. We're not going to check if you've done it before. We're not going to see if you're enrolled in a smoking cessation program at the time. You're just immediately going to pay that fine. And for me, I can support this amendment because, as was stated by the author of the legislation, this has been in effect for some time. I believe that over the years, there's been some awareness already brought to this issue to bear quite a bit. I think that if you're an adult and there's a minor in the car, we talked about common sense earlier. I think it really is common sense now at this point. No one should be lighting up in the car if there's a minor. So I don't think that this first pass at this point in time is prudent anymore. I think that maybe amending it out at this time would be a good progression of the law so that we're being more firm-handed about something like this. And for me, I just take this position because it has to do with the safety of a child and their exposure to secondhand smoke. I mean, they may not have been previously convicted of the violation. That doesn't mean that they haven't been conducting it before or they haven't been guilty of it before. It just means that they never got caught. So they could have been exposing children to secondhand smoke for years, and then finally they got caught, and then they're going to get that first pass. I think we've kind of moved past that. So I think maybe the time has come for us to actually amend this out and say once you get caught with that, you are immediately going to be assessed that $100 fine. And really, for me, this involving minors, and the fact that they're riding in the car because more or less they have to, either they don't have their own car or they don't have their driver's license and they're being, transported from place to place. Maybe even that fine should be higher, but I don't want to take it too far, but I think that maybe amending out lines 7 to 11 at this time would be in the best interest of the child who is the passenger in these vehicles. Thank you, Madam Speaker.
You're welcome. On the amendment, Senator Tom Adda.
Thank you, Madam Speaker. I rise in support of the amendment to delete lines 7 through 11. And first of all, I I wonder if we even know what the cost is of a smoking cessation program. For all we know, it could cost more than $100. So, without that kind of information. But maybe an alternative to, but I think that we need to go one step further if we're going to delete lines 7 and 11 and make amendments in subparagraphs B, D, and E. And if we read the penalties that are being assessed in line 5, it says, shall be subject to a maximum fine of $100. And to me, I read that the judge we're giving the judge the discretion to fine anywhere from $5 up to $100. So, maybe first offense, the police officer reports that, there was a newborn child in there. There was 3, children under the ages of 6, 7, and 8. Maybe that guy should be slapped the full $100, even on the first offense. And then we also need to go down to in subparagraph D, and the penalty there needs to be adjusted so that then on the second offense, the penalty should be no less than $100, but no more than $200. And then on the third offense, it will be no less than $200 and up to a maximum of $500. So I support the amendment in deleting lines 7 through 11, but I think we got to go one step further to make those amendments that I have suggested. Is it appropriate to make an amendment to the amendment now, or should we first vote on the first amendment?
The amendment would only have to be within the 7 to 11, but
Okay.
after, depending on how that goes, then I would allow you to come back then to make
Okay,
the amendment.
fine.
Is there anybody else who would like to speak on the amendment, the Tony Ada amendment? There being none, and there is an objection. So where are our members? Yes, beforehand. Senator Ada, while we're trying to get the others in, you want to close?
Yes, thank you, Madam Speaker. Madam Speaker, when you look at this bill, and we talk about being outside, 20 feet away from the building, 30 feet away from the building, we want to make sure that we stick to those parameters. But I think when you're inside a motor vehicle, it's something different, especially when the windows are rolled up, the air conditioner is on, and you got that recirculation button hit. That's all that recirculates in the car. It's the smoke that the person is in the car smoking, and the children are inhaling. And even the lady who's pregnant is inhaling, and the unborn is getting some. We're not talking about outdoors. We're not talking about out at the beach, in open air. We're not even talking about at the airport. This is a confined space, no bigger than 5 by 5. And we're going to subject these kids to inhale secondhand smoke. I hope my colleagues can support the section to delete, my amendment to delete, and hopefully that if it passes, that the next amendment to increase the fines would pass also. I would support that, because I believe that if we're going this step to take smoking out of the bars and move smoking away from the front doors of buildings and such, then I think a confined space like a car should, it should have harsher penalties. especially when you have kids present. And I thank my colleagues who spoke on the motion. Thank you.
So there is an objection to the amendments. I'm going to call for the vote. All in favor of the deletion of lines 7 to 11 on page 8. All in favor? All in favor, please raise your hand. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. It passed. You got 10 votes. Okay, Senator Ada, I'm going to go back to you then, because in a way, Senator Tony Ada was the last speaker on the main motion. Well, Senator, one moment, please. So, Senator Ada, are you done then? Okay, thank you. Senator Tom Ada.
Thank you, Madam Speaker. So now that that amendment has just passed, it's appropriate now to go ahead then, I believe, to make the following amendment, and to make an amendment in subparagraph B.
I think we need to bifurcate this, if you don't mind. I think it'd be better, it'd be easier that way.
Say what?
We'll just do one at a time, like
Sure.
B, and then and renumber to C.
Yeah. Actually, there's subparagraph A, B, and B are fine. Subparagraph on line 12, we'll renumber that, and that will now be subparagraph C, and should read on line 13, after the word subject, be subject to a, oh gosh, I'm going to need to write this out. Anyway, shall be subject to a fine of no less than $100 and no more than $200. So it provides a range. There's a floor and there's a ceiling to it. So be no less than $100 and no more than $200 for a second offense. If that's clear enough, maybe the clerk can go ahead then.
Yes, so the clerk is saying yes. So
Okay.
the first amendment then is on page 8, the renumeration of D to C, line 13, after the word to, that means be subject to no less than $100 and no more than $200 for a second offense. On the Tom Ada amendment, I have Senator Nicholas.
Thank you, Madam Speaker. I just had a couple questions. I'm trying to understand why we would set a floor and a ceiling. I mean, why don't we just go with a flat fine? You know, first offense $100, second offense $200, third offense $500. I'm trying to figure out where would there be like room to say, okay, it's going to be 150 or 175. And the reason I'm asking is because I also want to understand, you know, does this really need to be something that actually has to go before a judge, or can this be a citation that they just go in and pay? Or do they need to actually take up court time, be put on the calendar? You know, because this is all going to take up costs and court operations, and so I wasn't a part of the original construction of this act. This was in legislatures prior to me being here, so I'm trying to understand how did we come up with this particular adjudication structure, and perhaps we can look at instead making it just be a citation that they go in and pay, because I don't see anywhere where a judge's, you know, the expertise, the time, you know, of the judge is going to be really necessary to come in here and adjudicate this. I mean, and I guess I'd like to pose that as a general question, maybe to the to the main mover of the bill, or to the mover of the amendment. Is there a reason why we would set this floor and ceiling range, or can we just keep it at a flat fine? And is there a way that we can actually not make this be something that has to go before a judge, or just go straight into a citation mode, but they have to just go in and pay to the courts?
Yeah. And maybe even the former judge might be able to respond to that
Right.
too as well.
Yes.
Yeah.
So I'd like to pose that question, Madam Speaker.
The question then is posed really for anyone here who feels comfortable enough to respond, is that Senator Ada will give his reason, I'm sure, as to why the range, but in terms of a specific dollar amount, it be a citation, go right into the courts and pay without having to go before a judge to make that decision whether any one of those ranges between 100 to 200 will be, filed, fine, the individual will be fined for.
Sure.
So maybe Tom, Senator Adat, we'll start with you,
Sure.
and then possibility maybe with the past legislation, maybe in terms of the research and what the committee has done, we can ask the chairman, and then from a personal experience from a former judge in terms of whether a ticket, citation, and all that. He doesn't want it to go to his court. So Senator Tom Adat, please.
Okay. I think the gentleman brings up a good point, that there may be some people who say, okay, fine, you caught me, I'll just pay the fine. And maybe we need to put a mechanism in here where in the case of that particular individual, he just puts his check in the envelope and he mails it in, and that's it. But what about the individual who says, hey, the kids were holding their breaths, And I know that sounds ridiculous, but he honestly believes that he doesn't, he should not be assessed a $100 fine or whatever, but he should be let off lightly and say, this is the first time I've heard of this law and all that stuff. And so we normally, I think our practice has always been to give the discretion to the judge to decide whether he's going to give him the full blow or, just as light as possible, just to catch his attention. So that part, I still think we've got to, keep that range, give that discretion to the judge. How we handle the individual who basically just says, look, I don't want to hassle with this. I don't have the time for it, and just writes a check and he mails it in, right? And he's probably about as sorry as a 2x4. We probably need to put a mechanism in for that. Otherwise, he gets scheduled to come in, and if nothing else, the fact that he has to get off, take time off from work, and stand before that judge and say, I realize the errors of my ways, I won't do it again, or the other guy, and so the judge will probably let him off easy. Or the guy that comes in and arrogant and say, hey, look, this is a stupid law anyway and all that stuff, the judge will probably slap him the max. So, 6 of one, half a dozen the other. If somebody has an amendment as to how we should put in a mechanism for the guy who just basically says, fine, here's your money, take it, don't bother me, and goes on his way. But otherwise, that is the amendment that I'm making now, and yes, it suggests that that individual will have to go and stand in front of the judge and plead his case.
Tell you what, we're going to take a brief recess because I just thought of this as well, that in terms of the next level in which where you want to go, that maybe that dialogue needs to take place. And I just thought that the other thing is the unintended consequences that maybe one of our members here, colleagues, might want to expand on the 3 strikes, because if this is one of those, and will it count as one of those, then you've got to consider that. So we're going to go in a recess. The legislature is back in session. Senator Ada, we left off, I know in the beginning, with an amendment you had proffered, but you may want to.
Thank you, Madam Speaker. Madam Speaker, I'd like to proffer a series of 3 amendments.
Before you do,
and-
before you do, Senator, because you're going to do 3 new ones, that we need to go back to withdraw your original one before the recess?
Yes, okay, so I'll go ahead and withdraw the amendments that I've made.
Yes, okay, so on that motion then to withdraw, which is the new subsection C.
Oh, no,
that
no,
new-
no. No,
That new language.
That remains. That remains. That already passed. So what I'm
No,
doing
that
is
didn't pass, we didn't vote.
Yeah, we
Let me
did.
see, wait.
So now what we're doing is we're tightening up the other penalty provisions.
Okay, Senator, well, this is what I've got, the chronology of what had actually happened. And is that at the time when you had proffered the amendment of no less than and no more than, the conversation, of course, went to Senator Nicholas about the possibility of an alternate paying, and then that's it. And that's when we had recess. So we never really voted on the no less than or no more than.
Oh, that's
That's what I was
correct.
saying.
Yes,
We didn't
that's
vote
right.
on that.
That's
okay.
right.
But in order then, if that is going to, the reason why I say is only to withdraw that, only because now you're going to have to go back to B and then start all over with C, because C is going to have not only that language, but inclusive of the alternate process, the same as in D.
That's
and
right. So,
E. You're right.
but the deletion of lines 7 through 11.
That's
already done.
That's done.
Okay. So I
We're
would like to
talking-
proffer then an amendment for
No, but
lines.
we need to finish, see what it is that we were on C. So we can't just leave C hanging. We've got to make some decision on C, but we can't really because we need to do the B. So the cleanest way to do it is just withdraw what you originally had proffered, and we do it clean with B first, then C, then D.
Okay.
Okay,
So I
but-
withdraw then my
Right, thank you.
amendment.
That's a fine. Can you please? Yes, it doesn't matter. You're fine for that. And then the motion is to withdraw that previous amendment of C. No objection, so ordered.
Okay.
Senator Ada, now we're going to start all over, and you do have 3 amendments.
Thanks. So, Madam Speaker, on page 8, I would like to make.
Senators, please give attention to Senator Tom Ada on
So-
an amendment.
Madam Speaker, on page 8, I would like to make an amendment to lines 4 through 6 to read as follows. A person who is in violation of subsection A of this section 90114 shall, upon conviction thereof, be subject to a maximum fine of $100 for a first offense. Alternatively, the offender may plead guilty to the offense and remit a fine of $100. So that addresses the concern of the individual who just wants to basically plead no contest, writes out the check and sends it in. Okay.
On the amendment. Anyone like to speak on the amendment? Are there any objections to the amendment? No objections, so ordered. Senator, your next amendment.
Thank you, Madam Speaker. So on the same page, on lines 12 through 15, I would like to make the following amendment so that then on line 12 it reads, a person who is in violation of subsection A of this section 90114 shall, upon conviction thereof, be subject to a fine of no less than $100 and no more than $200 for a second offense. The fine shall not be suspended by the court for a second or subsequent offense. Alternatively, the offender may plead guilty to the offense and remit a fine of $200.
On that amendment, any objections? No objections, so ordered. Senator, the next
And
amendment.
the next amendment is for lines 16 through 18 to read, a person who is in violation of subsection A of this section 90114 shall, upon conviction thereof, be subject to a fine, delete the word maximum, subject to a fine of no less than $200 and no more than $500 for a third offense, and for each additional violation thereafter. New language, alternatively, the offender may plead guilty to the offense and remit a fine of $500.
On the amendment, any objections? No objections, so ordered. Thank you, Senator. Do you have any other amendments, or would you like to continue to speak on the main motion?
I'm done. Thank you.
Thank you, Senator. Back to the main motion. Is there anybody else who would like to speak that have not spoken earlier? Anyone who would like to speak? Senator Rodriguez to close.
Thank you very much, Madam Speaker. And thank you to our colleagues for this, the deliberation on Bill 143-33 today. I want to thank also my colleagues for the amendments that were proffered here today, and for those that have sustained the moving of these amendments. I just want to share, Madam Speaker, that although there were a lot of concerns about how this will be enforced, us now bringing on private security personnel, empowering them to be able to carry out this act, we would really take into account a lot of these and what types of challenges and obstacles that these provisions may face in moving forward. And that's why in the provision where it allows and empowers private security personnel, it's got to be, the prerequisite there is that it's got to be a company, a business, a private security company, or an establishment that hires a private security company to elect for their security personnel to be able to enforce this law. So it's not an open-ended authority that we're providing to just any and all private security personnel. So in terms of any liability that may arise in the future, it's going to be the decision really of these establishments who choose to have their employees carry out this and enforce this law. Another important matter that I want to be able to speak on what we've discussed here, since we've taken out the provision on civil suits and giving our people another avenue to ensure that this act is enforced. I want to just, and I know it wasn't talked about during the discussions today, but I want to direct the body's attention to the last page, page 9 of this bill, section 11. The existing Natasha Protection Act now, Madam Speaker, allows for a citizen's arrest, which is 8 GCA, subsection 20.20. And we've removed that because just like some of the concerns that were raised here about the confrontational aspect of perhaps trying to enforce this law is very serious. That's why this bill requires that we take almost a year to really get the individuals, the departments that are experts in law enforcement involved to really train our people that we are empowering now to be able to enforce this in a proper and safe manner. I felt that if we left the provision of a citizen's arrest, it really poses a concern that, as we've heard here today, that a lot of our colleagues have expressed. So that's, I think that's something that we need to highlight and ensure that we remember that we've taken into account the concerns that our colleagues have brought forward today, Madam Speaker. At the end of the day, Madam Speaker, really this bill is protecting our community. The need for protection from secondhand smoke in all workplaces and public places has never been clearer. We have a lot of more information, more studies that have been conducted. If you really compare from what we have today to what was before us in 2005 when this first act became enacted, a lot has evolved. And so us including bars now into the list of prohibited places where smoking occurs is really, as we've heard other speakers here today speak about, is for the protection of those that work in these establishments, not just the waiters or waitresses, but it's for the patrons and also for the entertainers that work in these places. And I want to reiterate again, Madam Speaker, that this in no way infringes in anyone's freedom. This doesn't say that you can't smoke, period. And that's why we have these provisions where that establishments must have a place that they designate outside in an open area for smokers to go out and smoke. And so we've taken that into consideration, but really it's to be able to protect those who are voiceless, who are really defenseless in terms of having to be somewhere and working in an establishment and having this type of environment. And so I know it's taken us over about 10 years to move this forward and progress in what we're doing here with the enforcement aspect of this bill, and also now including bars into the list of prohibited places. So I'm really hoping that our colleagues, I want to thank, number one, first, all our co-sponsors here in this measure, but also ask our other colleagues, now that we've really refined this bill and I believe made it even a better bill, that they seriously consider supporting this for the good of our community and our people. Sejus Masi, Madam Speaker.
You're very welcome, Senator. So on the motion then to send Bill 143-33 to the third reading file without any objections, so ordered. Okay, thank you. Senator Tom Ada on 195.
Thank you, Madam Speaker. Madam Speaker, I move that Bill 195-33, as amended by the committee, be placed on third reading, and I'd like to discuss it.
And 195 is as amended. Okay, Senator, as amended, right? That's the bill we're working with?
And it reads, Bill 195, as amended by the committee.
As amended. Okay, thank you. You may proceed then.
Thank you, Madam Speaker. Madam Speaker, the page is passing out some handouts, which will help everyone to kind of get an orientation of where this lot 3470 is located at. Lot 3470 is property in Asinan, Chalampago that was reserved by Public Law 2218 back in 1993. And it reserved, the entire lot consists of 117 acres, and Public Law 2218 reserved 95 acres for various government agencies based on what they said their requirements were. And so what Bill 195 does is it recognizes the fact that after over 20 years, the the agencies really have not done anything with the property. They have not complied with Public Law 2218 in terms of coming up with a conceptual plan for what they want to do with the properties that were reserved, and have not come up with financing alternatives. But probably even more significant is the fact that when we had the public hearing on Bill 195, the agencies that have reserved property acreage in lot 3470 basically came in and said, you know, we're really looking for other places to build the facilities that we need to build. But I'm getting a little ahead of myself. Let me just kind of orient where this property is. So lot 3470, if you take a look at Exhibit 2 of what was handed out, you'll see there an aerial photograph, and lot 3470 is shaded in green. And you'll see on the east side of the lot, there's basically about 22 acres of property that was set aside that actually belongs to the Chamorro Land Trust, and there's an existing farm in there. In fact, the farm was certified several years ago by the College of Agriculture as really being a model farm because it's very good. The soil in there is good for farming. On Exhibit 3 of the handout gives you a better orientation of where lot 3470. So you can see on that exhibit up on the northwest corner is where the ORDOT landfill is. And just to the northeast of that is the ORDOT Community Center. There's the ORDOT Elementary School, and the Agata Johnston Middle School is directly north of lot 3470. I think to give a better orientation of where this property is, everybody has traveled the road going to and from Leo Palace. And so if you're coming from Leo Palace, you'll see there on the left side of the handout, it says Leo Palace Road. And you'll see there where the arrow points down where it snakes around, where there's a bridge. And everybody remembers that bridge because if you're going too fast, you're going to go airborne. And so almost to the right of that is where this lot 3470. And I think probably a good way to describe lot 3470 is that it is wetlands, and it is basically hills and dales. And the best use of that property really would be for agriculture, and in spots there possibly for residential leasing. Now, so the objective of Bill 195 is basically to take this 95 acres that was reserved by Public Law 2218 and just take it and return it to the Chamorro Land Trust inventory so that they can lease it out for agricultural and residential leases, because that is really probably the better use. Now, it's important that we take a look at what when we had the public hearing on this, basically what the agencies had to say about the bill. So, in the case of the Department of Education, they came in and their testimony was basically said, GDOE agrees that it is not in the best interest of the island to continue to reserve properties not conducive to school campuses. If you see in the in what was reserved was for the Department of Education back in 19 when was that? under Public Law 2218, they said that they needed 35 acres to build a middle school. And so they said, we want 35 acres in Lot 3470. But then in the public hearing and the written testimony they gave, DOE said, DOE agrees that it is not in the best interest of the island to continue to reserve properties not conducive to school campuses and supports opening of these properties for their highest and best use. However, we would hope that you would consider reserving properties in the North and Central Guam for future school sites. And we discussed that very point in the preceding 3 bills, which would take basically properties that were reserved for DOE, and the requirements have been fulfilled since then. So therefore, the requirement for the land is really moot, and the 3 previous bills then proposes to return those properties, total of about 105 acres, back to the Chamorro Land Trust. Now the Department of Public Health came in. The mayor of Chalampago, Mayor Gogui, he opposed the returning of the land, and basically his reason is that what better place to develop than in the central part of the island? Okay, so he's of the position that you can go in there and build despite the fact that it's hills and gullies and it's a wetland in there. And really, if you take a look at the handout, the area is landlocked. There's private properties. It is surrounded by private properties. And the only way to get into there right now is going through basically through the housing area in there, real narrow road. You're not going to be driving in school buses in there. So the access is really limited. And the only way you're going to open access into that area is you're going to have to condemn property to be able to then get the right-of-way into Lot 370. But nonetheless, the mayor objects to returning this property to the Chamorro Land Trust because he would like to see some development occur at least in his vicinity, in his neighborhood, and believes that this is a good place to develop. So that's the mayor's position. The Department of Public Health and Social Services, they have basically, they had 8 acres that was set aside. Already they have used up 6 acres of that as land exchanges because they needed, for example, they wanted to build a laboratory. So they built it up on Chamorro Land Trust property up at Department of up in Dedido, adjacent to the clinic there. Well, that makes sense. It's there's infrastructure. It's flat. Easy to develop, to construct on, and all that. So they made a area for area exchange was made, and that's where the laboratory was built. There was also 2 acres that was set aside for the children's foster home, but they came in and they said, "Hey, this is no place. Asinan is not a place where we want to build a foster home, for a number of reasons. There's no infrastructure in there. It's going to be difficult to construct in there, and we really want something like a foster home close by to medical facilities and in the urban area, basically." Then they also have another 2 acres set aside for a homeless shelter. Well, if it's not good enough for public health for a foster home, I have no reason to believe that it's going to be good enough for them for a homeless shelter. But in their testimony, they said they don't support the bill, but they need the land in order to develop initiatives for assisted living, testing laboratory, for the military buildup, etc. However, they point out that the area, lot 3470, doesn't have the proper infrastructure, so we are requesting to seek an alternate site because the cost to build infrastructure would be too expensive. They further go on to say that they are already taking a look at the next lab facility. And there's already internal discussion within the Department of Public Health about property in Dedido near the lab that is being built now. So, it's interesting how they set aside property in lot 3470, but they're really looking elsewhere. And so it asks the question, so then, really, then why do you object to taking these properties and returning it to Chamorro Land Trust? And the answer was, we're leaning towards possibly swapping. So they want to use this to barter. It's kind of like, oh, Chamorro Land Trust, would you want to trade a property that's in an urban area? It's got good infrastructure. You can develop, you can construct on there very easily and exchange it for property here in Asinan, which really is probably better used for agriculture and to a limited extent residential use. But they want to hold on to it. So they're objecting to the bill because they want to hold on to what they've reserved for bartering. And I find that rather revolting because, let's not play with land. If it's better suited for agriculture, let's use it for agriculture. If it's not suited for constructing a laboratory or a homeless shelter, then say so and identify where you think it has a better use. Because quite frankly, when these reservations were made, it was a tabletop survey. They said, here's 195 acres here. Put it there. Never set foot to determine that it was wetlands and hills and gullies. Then the property was also set aside for the Guam Memorial Hospital. We sent them a letter and says, hey, we had a public hearing. Do you have any position on Bill 195? Never heard from them. So I guess they probably really don't care one way or the other. Department of Mental Health and Substance Abuse, set aside for them is 17 acres for an adult residential treatment facility, 10 acres for residential treatment facility, and 2 acres for a crisis center. And they basically came in and they says, oh no, we need this property for all these things here. And again, you got to ask yourself, one agency already came in and said, that place is not suitable for a foster home. It's not suitable for a laboratory. Why would it be suitable for a residential treatment facility? Why would it be suitable for a children's residential treatment facility or for a crisis center? So these were the reasons that were given as to why there was objection to taking this land, to return it to the Chamorro Land Trust inventory for agricultural and residential leasing. And so I still continue to emphasize the fact that when in fact, for example, when the Department of Public Health came in and said, we need to build a foster home, we've got money to go now, we just need to identify the land, this legislature came through and identified the property up in Barrigada Heights. And a land swap was made. A land swap which, although I thought was rather, Chamorro Land Trust came on the short end of that stick because it was an area for area. It was trading property that belonged to the land trust up in Barrigada Heights, which maybe had a value of, $50 per square meter for property in Asinan that maybe had a value of $10 per square meter. But, nonetheless, a area for area exchange was made, and unfortunately the Chamorro Land Trust came out on the short end of that stick. So, Madam Speaker, I think that taking this property this lot 3470, transferring back the 95 acres that was set aside for the government agencies, and deleting that reservation, taking those acreages back into the Chamorro Land Trust inventory, certainly would recognize the fact that the higher and better use of that lot would be, of that 95 acres, would be for agricultural and residential leases. And so, Madam Speaker, I ask that, and I do know that there are some people who, there may be some in here, who would object to this simply because of the very mentality of, no, let's hold on to it for a barter so that we can, use it to barter with the Chamorro Land Trust, and and hopefully we can do another one of those $50 per square meter in exchange for a $5 per square meter property on an area for area. But I assure you that's not going to happen this time. So, Madam Speaker, notwithstanding that, I think that when a legitimate need comes up that needs to be satisfied, whether it be to build a laboratory, whether it would be to build a foster home or some kind of a residential treatment home, this legislature will step up to the plate and will satisfy that requirement, regardless of whether there's land to exchange or whatever. If the need is there, it's got to be satisfied, and it's not a tit-for-tat sort of thing. Thank you, Madam Speaker.
Welcome, Senator. On the motion, Senator Munoz-Barnes.
Thank you, Madam Speaker, for giving me the opportunity to speak on this Bill 195. Madam Speaker, I just want to say, based on the retiring speaker's presentation, that I personally do not agree with how the story was told. I understand when Public Law 22-18 was first signed into law, which was Bill 483 at the time, it was the intent of this august body to provide for the basic services to our people from the government of Guam. There set aside a list based on what was needed for the government to build in order to provide for the services for our community. And with that being said, there was a separation and a divvy up of proposed facilities within the different villages, the lot numbers, and the acreages that were given. I want to share with you, as recent as this recent last term, when there was talks about building a facility because resources were available, the concern was not about having the facility be built, but what was the government, the Chamorro Land Trust, going to get dollar for dollar, acreage for acreage. The need for the foster care was evident. The need based on what was provided by the government showed that the facility needed to be done. But because this august body didn't agree, there was a compromise. And that compromise was to have Chamorro Land Trust choose and decide what best in their inventory that they would have. I'm going to say, Madam Speaker, that any property here on Guam is good property to build on. But as you know, the story goes on. In order to make things work, you're going to need resources and you're going to need money. 20 plus years later, we're still looking at facilities to build, and we still need facilities. And it is not about seeing what we could do to keep one property to barter so we can get another property or a better property in another village. It's about what the government of Guam can work today. And I'm going to tell you, Madam Speaker, that we do have a government that is trying to help. And we, as an august body, need to do our part. Now, the easiest way to work things out, to provide for our community, is to get the stakeholders involved to come to this body, because the law says in order for us to build anything, to do anything on government property, we have to come back to this August body, to this legislature. And that is what has been happening. We went through some red tape, a lot of red tape, a lot of snags, but in the ultimate end, there was a compromise on the last term, and we gave Chamorro Land Trust the opportunity. That's why Barragata Heights was chosen over Tamuning, because there was some concern and some opposition from the residents of what kind of facility was going to be built on prime property. I'm going to share with you, Madam Speaker, that I don't have a problem with Bill 195. I do know the intent of what we need to do to provide for our people, whether it be residential, whether it be agriculture. But I also know that we as a body have to make sure that the facilities that were set aside to be built, the only reason why we can't build there is because we don't have the proper infrastructure. And to build upon that is we're going to have to pay for infrastructure. And we don't have that right now. But there are other places on this island that are more accessible, that have the availability of water and power and other utility needs that would make it easier for our government to build the facilities that are needed. And yes, based on the previous speaker and the author of this legislation, that yes, there is a provision that says the property that was designated for the homeless emergency shelter was designated. It shows on Public Law 2218 that it was 117, but we know that that's a portion of 117.94 acres. What I do want to ask, Madam Speaker, and I'm trying to figure out what kind of amendment I have, is there is, and I was told I can't speak about proposed legislations that are introduced but didn't have a public hearing, that it can't be talked about. But I want to say that Public Health, Chamorro Land Trust, and GURA, and the present administration have been working together to find a suitable place that has the available utilities intact to look at the best use and high use possible to build this emergency shelter. And that, Madam Speaker, has a bill introduced working with the stakeholders, the government stakeholders. And I am asking...
And I'm going to give you the same response.
No,
as
I
the
understand,
Vice
Madam
Speaker
Speaker.
did,
I understand. The bill hasn't been heard, even if it was introduced, but I'm understanding that there's a need, that there is collaboration with the government of Guam, stakeholders, to build an emergency shelter. There is funding that has been provided that's set aside right now to build
But
this.
that's not
And there is
germane.
collaboration.
It's not germane to this bill, so I will not entertain
Madam
it, so.
Speaker, I'm asking that there has been a provision in this body to set aside portions of this property on lot 3470 that would give for the homeless shelter. I'd like to keep that section of 2218 intact. I did receive message from Michael Borja, Department of Land Management, who says, who talked about the introduction of, I mean, I understand and concur with the need to introduce an amendment to Bill 195 to preserve 2 acres reserved in Public Law 22-18 for public health to use as a homeless shelter. He talks about a recently introduced measure and that he'd asked that the transfer of 2 acres be more appropriate to a location and establishment for this emergency homeless shelter. So I want to say to you that this government did not forget. I know it's been 22 years later, but so some of the other facilities that we have just recently built and completed, it did take a lot of time. This is no different. So I want to ask legal counsel. I did have something proffered, and I think my colleagues have the copies. There's an amendment that I introduced, and I'm hoping that my colleagues can look at it. And if you can have a minute, I don't know where the.
No, we don't have I don't have an amendment here.
If I can have the pager, please look at the amendment. Copies were made earlier. It says on Section 2, property transfer lot 3470, municipality of Chalampago, as shown in Exhibit
I'm sorry,
A.
nobody has any amendments.
Can we get, Tom, you made copies earlier? Madam Speaker, if we can
have a
have.
recess. Commissioners, back in session. Everyone should have a copy of the amendment. Oh, not yet. Can someone please make sure Centrata gets a copy? Okay, you may proceed, Senator.
Again, Madam Speaker, I'll reread the amendment. The change would be on line 12, page 2, section 2, property transfer lot 3470, municipality of Chalampago, as shown in Exhibit A, Department of Land Management, map number 161 FY93 shall be transferred to Chamorro Land Trust to be added into the Chamorro Land Trust Commission lands inventory for residential and or agriculture leasing, except that the Chamorro Land Trust Commission shall reserve at least 2 acres of property described in here for the Department of Public Health and Social Services homeless shelter, and again, it's pursuant to Public Law 22-18. Madam Speaker, based on recent surveys, we have found out that there is definitely a need for an emergency home shelter. I want to share again that the Guam Housing Urban Renewal Authority has secured funds for a project through the United States Housing and Urban Development Authority, and that I want to share for the record that we've been working with Public Health, Land Management, GURA, and all the other stakeholders, the nonprofits involved, and that there may be a place more suitable for this, but that will probably be more reasonable to work with. But at this time, we'd like to hold this property because we know that based on the numbers that have come out, Madam Speaker, just not even counting 2016, based on the estimates of the homeless persons here on Guam, for 2015, there have been an estimated number of 1,280 plus homeless individuals. Out of that, 40% of those individuals are under the age of 18. There are more males, 52% of that are males, and 48% of those homeless are females. And as one of our colleagues spoke about just recently on another issue, the representation of the ethnicity of the folks that are homeless here on our island represent more than 42% of the homeless are Chamorros. Madam Speaker, what the government has today and those who help in providing shelters for those in need, we probably have a total, if the calculations that have been submitted to me are right, no more than 74 beds that have been utilized. You and I know that we don't even have to look far at what's out there at the intersections on the roadways, and asking for donations it's not even about needing medical resources. Right out based on the need for asking for money at the intersection is, I'm homeless. So I'm just asking my colleagues to please help me consider this amendment. I want to continue as Oversight Chair of Housing. I want to be able to find solutions and to work with resources, not from our own general coffers, but from grants that are provided to us like what HUD has to offer and what GURA has in place right now. Madam Speaker, you've seen successes that we've built, the houses that we have been providing for our working class families, for those just over the poverty level but not able to buy their own houses. With a little help and a little bridging, the opportunities were there for them to build and have a home for themselves and for their families. We're continuing on with those programs, Madam Speaker. But the numbers that we see today are very alarming. And when the discussions of building this emergency home shelter, I would not be doing my job as a public servant if I turned my back on at least not trying. So I hope that this motion and this amendment, that I could get the support from my colleagues. Thank you, Madam Speaker.
You're welcome. On the amendment, Senator Tamara.
Thank you, Madam Speaker. Madam Speaker, I would have to object to the amendment for the simple reason that I think the need for the construction of a homeless shelter and the reservation of 2 acres in Asinan should be really treated as being mutually exclusive. It isn't as if we took this 2 acres and returned it to the Chamorro Land Trust inventory, that just basically makes it impossible to build a homeless shelter. I mean, if we're going to hold it, then hold it because we're going to build a homeless shelter there. But don't hold it because we got plans to build a homeless shelter and all that stuff. I mean, I don't know. We have yet to get a public hearing in the village of Dedido as to whether I think the area being looked at for where this homeless shelter is going to be built is going to be close to basically the existing village. Maybe those people are not going to agree to having a homeless shelter built in their neighborhood. So let's treat it differently. We're wanting to return Lot 3470 back to the Chamorro Land Trust inventory, recognizing the fact that its higher and better use is for agricultural purposes. And insofar as the need for land for the Chamorro, for the homeless shelter, then let's deal with that separately. If you need to build it in Barrigada Heights, then let's deal with that then. Quite frankly, holding this 2 acres in Asinan as a bartering tool is a smokescreen so that it makes it seem like, we didn't take anything away from the Chamorro Land Trust. We just gave up 2 acres over there and we're exchanging it for 2 acres of Chamorro Land Trust property over there. I don't think we should be playing that game with land. And so let's treat it as being mutually exclusive, return Asinan, everything back so that we can lease it out for agriculture and residential use and not, save it for, I just don't see how the two tie in. So I would have to object to the amendment, Madam Speaker.
On the amendment, Senator Nicholas.
Madam Speaker, the amendment speaks to the greater question of using our government land for goals and objectives of this government. And the dialogue that we've had the other day about how when we put it into the Chamorro Land Trust, we limit its availability for use unless we're going to go in there and take something else right back out again. If we can swap 2 acres of Asinan for 2 acres somewhere else for a homeless shelter, that will be a whole lot better than us going out and spending $5, $10, $15 million for property to build a homeless shelter. You know, if we could go back in time, perhaps we should have swapped a Asinan for some of the land down in Ladon before we went down there and incurred a $38 million plus interest liability that our people are still accruing. These things are not mutually exclusive, Madam Speaker. This is the land of the government of Guam that is up to us to be able to prudently manage in order to achieve the goals and objectives set forth by our people. And so if one of our priorities is a homeless shelter, then we need to understand that the homeless shelter is going to require land, and we either provision for it based on the existing land inventory that we have, or we go out and we spend money to buy the land for it, because we're certainly not going to be building it in the trees. And even then, the trees still need land. So, similar to the greater question that I'm going to speak to in the overall bill, this specific amendment is a direct example of the fact that we really need to step back and understand that planning for the use of the land that's available in this government needs to be done with respect to what it is that we want to achieve in terms of our goals and objectives. And if putting it into the land trust is the paramount goal and objective, if the needs of the land trust are so great that this Asinan property should go in there before we build a homeless shelter, then that is the opportunity cost that we need to really be upfront about. And if it is so pressing that this land goes into the land trust first before we build the homeless shelter, then that case needs to be made. But there's 5,000 acres in the land trust already. There's 0 acres for a homeless shelter. 5,000 to 0. The affinities that we have for the land trust, Madam Speaker, must never be lost. But the responsibilities that we have to prudently manage these assets to achieve the goals and objectives of this government for the benefit of our people requires that we do not mutually exclude these issues, but rather understand that when we have land, we can either do one thing or the other with it. And this amendment is basically saying we're going to set aside 2 acres necessary for a homeless shelter. And I would beg the question that it demonstrates the future need for land for additional projects in this government going forward. Because 20 years ago, no one would have said we needed a homeless shelter. 15 years ago even. Or even a foster children shelter. So let's really take into consideration these choices that we're making with respect to this property, and really try and understand what is the urgency of putting this additional acreage into the land trust when there's already 5,000 acres in there, 5,100 some if these other bills pass. I support the amendment for what it represents, and I'll speak to the greater question of the bill when we're on the main motion. Thank you, Madam Speaker.
Madam Speaker, just a point of information.
Yes, please state.
The retiring speaker indicated that we probably should reserve this 2 acres as possibly a asset that can be used to that if we're going to build a homeless shelter on private property, that then we can use this as an asset to kind of help pay that off. But the fact of the matter is that the homeless shelter that's being referred to has already been identified to be built on Chamorro Land Trust property. It's not going to be built on some private property.
Okay, thank you for that information. Does anybody else like to speak on the amendment? Senator Blas? Oh, a brief recess. session. On the amendment, there's an objection to the amendment. Does everybody have a copy of the amendment on your desk? Yeah, were you able to read, Senator, did you get the amendment? Oh, okay, I just want to make sure everybody has a copy of the amendment. So since there is an objection, then I'm going to have to go for the vote. So all in favor of the Munya-Barnes amendment, please raise your hand. The amendment failed. On the main motion, does anybody would like to speak on the main motion? Okay, I have Senator Sir Nicholas, and if anybody else, please indicate by raising your hand, and Sergeant at Arms will let me know.
Thank you, Madam Speaker. You know, in listening to the dialogue and in just observing how things are trying to be managed here, I think that we have a structural problem with respect to asset management in this government, particularly with respect to land that's owned by the government of Guam. I think what we need to really start considering is the formation of a land bank to be managed by the government, so that we can have these lands identified, have their uses collaborated on with the greater concerns of the community, including all of the agencies that might have various long-term visions and projects, and then from there begin determining how we're going to be allocating these banked assets. Because right now what we're doing, or what it appears to be with respect to Bill 195 now, is we're taking an additional 100 acres that we're saying we don't really, we don't have a clear understanding of how we're going to go about using it, so let's put it in the land trust. And then we have concerns about, okay, well, if we need land for something else, do we go into the land trust and take it back out? Do we reserve portions of it for homeless shelters? Do we reserve portions of it for schools? How do we go about debiting and crediting land for the purposes of capital projects throughout our community? I think that, that's something for me that's really been an eye-opener throughout this whole process. And I appreciate the passion of all of my colleagues in advocating for their positions, because sometimes these things become clear when we're very, very adamant about what it is that we're trying to achieve. And I would like to first make it very clear that I think that every single intention thus far with respect to all these bills addressing lands in this session have all been a noble enterprise, because they really are not people trying to do something negative. They're all just competing positive interests. So for me, I'm just trying to reconcile now the question of, are we really now with these additional 117 acres or so, really managing it the way we should be by putting it into the land trust and then saying, hey, if the government has any future needs, we could always come back and make that decision, because that's how we've done it in the past. But I want to kind of step away from the way the legislature would go about solving these things and really put it into the perspective of the people. Because from the people's perspective, land in the Chamorro Land Trust is supposed to be for the Chamorros. Residential leases, agricultural leases. And even now that we've authorized them commercial leases to generate revenue, to get those residential and agricultural leases out to the beneficiaries of the land trust. And so if the idea is put it into the Chamorro Land Trust, we can always take it back out again. Operationally, as policymakers, that can happen. But from the perspective of our people who have come to understand the Chamorro Land Trust to be a trust, a trust where the land is going to be used for a specific purpose, every time we put it in and take it back out again, it's like we're doing something we're not supposed to. And that's kind of where I'm coming from in all of this. In all the previous discussions that we've had the land bills, and also with my concerns about this one. Because we are going to have future land needs in this government. And how do we go about meeting those land needs? We have land needs right now, Mr. Daniel Perez from Inarahan is always very even-spoken, comes in with his little notepads in public hearings, and he makes it very clear that Route 4 is built on some of his family property. Some of it, I think, is still getting taxed. He's still dutifully paying his property tax. But the underlying problem there is that we can't get federal funds to fix Route 4 in Inarahan because of those unresolved property issues. How do we go about resolving those property issues? Again, we can either monetarily compensate them or swap land. It's not about bartering or any other adjectives that we want to use. Those are the instruments that we have to resolve these concerns. We're going to need additional land down in Tumon to be able to address the flooding down there. I've heard Gita throw out a price tag of $14 million. So the question becomes, we can either swap land to be able to mitigate that problem, or we can come up with $14 million, which, based on headlines that I've been reading since I've sworn in this legislature and the one previous, we just don't have. So how do we go about addressing these concrete, in-our-face land issues with the resources that we have available to us to address them? I think that we need to come up with a better mechanism. I think that the idea of putting it in the land trust and being able to go into the land trust and take it back out if we have to for whatever reason, I don't think that that is consistent with what our people's expectations are of the land trust. And that's why in a previous conversation, it was brought up that when we were talking about using land trust land for schools that have obviously proven very necessary and a good public service to our community, they were still met with a lot of resistance, because the public's expectation of what's supposed to happen with the land and the land trust was not consistent with what the actions of the policymakers in this body were taking at the time. And so for me, it's like, okay, we're going to put now another 117 acres or so in there, because right now we can't see a better use for Asinan any more than I think anyone saw a better use for Luzon. All of a sudden now it's a $38 million property with accruing interest. By the way, I would like to get whoever appraised Luzon to come up and appraise Asinan, so that we can probably use that for a very high value, high dollar swap. But I digress. My point is that the needs of this community are very difficult for us to forecast. And something as obscure and seemingly out of the way and, of little value, relatively speaking, as Asinan, can all of a sudden turn into the next Luzon. And in the end, Madam Speaker, the only ones who are going to be footing the bill are the taxpayers of this community, the people of Guam. And so our inability to properly provision for those unforeseen requirements falls back on the taxpayers and the people that put us into office. So I listen to all this, and I struggle with all of this, because I think that we got to come up probably with a better way of doing it. I don't think that bills 192 all the way to 195 and the idea of putting in the land trust and increasing that inventory from 5,000 acres to 5,225 acres is the way to go about doing it. And I think that this also speaks to the bigger question of the fact that we really need to do an assessment of the total assets of this government and whether or not they're being put to their highest and best use, and whether or not they are being incorporated or considered in the greater planning of this government, from health, education to public safety. Because, we have a lot of underutilized assets in this government. We really should have a website where we can go to and click on and see where we have all these different, acreages. Geez, in this session alone, we're increasing the 5,000 acre inventory in the land trust by 5%, 225 acres all of a sudden out of nowhere. I had no idea we had 225 acres to put into the land trust. Any more than I thought we had 225 acres to swap for Mr. Perez, or to provision for the flooding in Tumon, or to potentially swap out for the obligation in Luzon.
Senator, please stick to the bill.
No, I am, Madam Speaker,
195.
and that is that,
Specifically
this bill is dealing with another 117 acres. And are we really putting them to the highest and best use? Did we really even explore all of those other options before we decided to put it into the land trust? And if the answer is, well, we put it in and we could always take it back out again, is that really what our people are comfortable with us doing with Chamorro Land Trust property? If we're going to say that this is land trust property, then we should really treat it as land trust property and not go back in and take it out for anything else. So I have a problem with this bill as well. And I don't want my vote to in any way be a reflection or to be misinterpreted, rather, as me not being supportive of the Chamorro Land Trust, but rather of me having an understanding that, our people expect us to, if we put it in, to leave it there. And I don't think putting these properties in there right now is what we should be doing, given all the other land needs throughout this government that we need to put to bed. But again, I appreciate the bill. I appreciate the passion of the dialogue. This has been a real eye-opening experience for me as well. And I got to say, I'm honored to work with a bunch of very, very intelligent colleagues who I learn from every day in this hall. Thank you, Madam Speaker.
You're welcome, Senator. So on the main motion, any others? Senator Torres?
Thank you, Madam Speaker. I just want to call everybody's attention back to the title and intent of the bill. If you look at Bill number 195-33 LS, it is an act to amend Public Law 2218 to transfer Lot 3470 back into the Chamorro Land Trust properties. And if you look at what Public Law 22-18 is, in 1993, a bill was passed by this body, Bill number 483, that was signed into law on June 1993. And what that provided was for these certain lands to be put in reserve for certain projects, as stated here. But one of the provisions in this bill that was signed into law was that, and I'm looking at that public law now, and I'm going to read from it. It provided for a reversion in the event that the conditions weren't met, that the set-aside conditions weren't met in the bill. And it says very clearly that the failure of the governor to meet the conditions hereby established within the allotted time frame shall cause the lands reserved in said paragraph B to revert to the Chamorro homelands. And so, there's a lot of discourse about the lands, the disposition of lands, the Chamorro Land Trust inventory. But for me, in looking at, the simple intent of this bill, this is really an act to cause that reversionary provision that was signed into law. And in that aspect, we can legislate for certain conditions. And we can legislate that if certain conditions aren't met, then this is the consequence. That's what this is all about. Over 20 years ago, there was a law that said these shall be reserved for this purpose. You must do A, B, and C. If you fail to do A, B, and C, it reverts back. Very simple. And that's what I believe the heart of this bill is. And in that respect, to enforce the reversionary provision, I think it's reasonable, and I stand in support of it for no other reason than that, to support the intent of this law as it applies to Public Law 22-18. All other matters, I think, are separate and apart and can be introduced in separate legislations. You're
welcome, You're welcome, Senator. On the main motion? Anybody else? Where's my friend? If he wants to speak. So, Senator Adat, would you like to close?
Thank you, Madam Speaker. Madam Speaker, I certainly appreciate the input from my colleagues who have taken the time to read the bill and participate in the discussions. But I'd just like to close by saying that what we've done these past yesterday and today with the putting down to the voting file basically 4 bills that will return approximately 200 acres of property to the Chamorro Land Trust for what is really deemed as for the better use of the property, which really has been identified more so as agriculture and residential, that we've accomplished that, and that I continue to emphasize the fact that I truly believe that when a need comes out in the community to build a public facility and land is required, and if the government has that land in its inventory, that this legislature will step forward to ensure that that property is made available. So it isn't as if we're taking property and putting it into this Chamorro Land Trust lockbox and it's never going to be touched again. So I would ask my colleagues to favorably consider this bill as well as the other bills that we've discussed in the past yesterday and today. Dahil na besoangan na Pt.2 siya madiskuti inigyap dan pago na ani no una na rason na para ta kumpli gini ni para tarikohi todo itano ni aga sa man matsalapon sa put no man marisetba para no hafa siya po fan mahatsa lo stagwa 20 anyos ni ti taza hafa matsogwin no debi pago na ta rikohi todos ti saitano sa tatungo hafa magay no gwinahata za jangin malignya na para man mausas siya na tono para guarlo para makahat hafa siya na sinay tautautan ni Paraguay gumania pues lekko mena sa tausa at tatsogwino i bill siya ni man madiskuti Nigav dan Pago, marikohi 200 na acres na tono ni sina para mana available para no gualo dan para famanhat sa guma no una no magahit kalan mustod bazo ni i konversasyon na guaham no kalan manduda na Chamorro Land Trust Commission no 20 no maligna ta tulaika at spia 8 na kalan no haftamano pero manehay itano lo ti lekko na ti mampareho inasota lekko na haga sa mahasuzi sti Chamorro Land Trust debi na tasiga tagiha mo na ni para tamano po mamanehay itano Chamorro ni para tautauta no ihinasu ni sumasangan na 20 maligna isti 200 na acres no misted tanahano tatig Chamorro Land Trust 20 maligna tahasu tabendi sinata posi siya dibita pareho talo ti pareho inasota sa ti enno ni ti umahalo menogi na sokuna para tabendi itano Chamorro put para taposi siya dibita pues no una be paisen to di senador gini di piso no mahasuzi raw masupoti siya na bill bill 180 bill 192 bill 193 bill 194 then bill 195 para minaw ki taw Guam ni dipulsihi itsamuruta pues enwa Madam Speaker Zeus Masi.
Welcome, Senator. On the motion to send 195 to the third reading file without any objection, so ordered. Senators, we're going to recess until tomorrow morning at 9.